means. And even if they don't have the means, they should be given reasonable treatment.
May I first declare that I am a practicing lawyer, and in occasions I do represent clients and advise and act on criminal issues. Mr. President, former British Prime Minister William Gladstone's famous phrase of, quote, "justice delayed is justice denied," seems to offer a perfect illustration of the problem of inadequate legal advice and assistance to citizens of Hong Kong. In the Chief Executive's 2017 policy address, the following commitment was repeated, quote, "enhancing access to legal aid and free legal advice to benefit more people who cannot afford free legal fees." To better reflect the increase in the charging fees for lawyers in the past 20 years, the government has finally agreed to consider a comprehensive review of an increase in criminal legal aid fees in 2016 after long periods of lobbying, with an increase in fees by 50% for counsel and 25% for instructing solicitors. Yet, lawmakers, the Law Society of Hong Kong and the Bar Association of Hong Kong have stated that such increase is still inadequate to encourage petitioners to take on pro bono work further without having a crippling effect on business. More importantly, duty lawyer fees have not been seen an increase since 1997 other than CPI adjustments. The problem of delayed access to justice in Hong Kong is again brought to the surface and should be dealt with in due course. Current government legal aid funding is directed only at representation. There is indeed limited assistance for an individual to obtain early legal advice, which will be explained further in due course. Quoted from proposed increase of criminal legal aid fees, that is a legislative paper, quote, "the difference between the hourly rates payable to civil lawyers and those payable to criminal lawyers in private practice undertaking legal aid work. The legal profession is concerned that the criminal law field will lose its competitive edge to its civil law counterparts in attracting legal talents and retaining experienced petitioners, which may in turn affect the quality of legal representation for the accused persons whose liberty is at stake." End of quote. The restrictions on recovering costs have indeed discouraged petitioners from litigating pro bono. As mentioned earlier, the government have finally agreed to consider a comprehensive review for an increase in fees payable to counsel and solicitors on criminal litigation work on behalf of the Legal Aid Department. This has come in response to the prolonged lobbying for an increase in criminal legal aid fees to make sure assigned solicitors and counsel in private practice are properly remunerated, and to take into consideration the fact that the legal aid fees payable to counsel and advocates were not substantively increased in the 2012 review. On the other hand, after the completion of the 2016 review, the duty lawyer fees remains to be adjusted administratively to reflect the 4% change in CPI. In other words, the fees for duty lawyers have not seen an increase since 1997, excluding CPI adjustments. The fees for duty lawyers are way too low when compared to their legal aid counterparts. Duty lawyers are normally paid for Hong Kong dollars 3,490 for a half day and 7,020 for a full day. Each volunteer lawyer who attends a legal service section under the free legal advice service receives a travel allowance of merely 300 Hong Kong dollars. Applying the same rationale behind the call for increase in criminal legal aid fees, the low fees provided under the duty lawyer scheme attracts junior and or less experienced criminal lawyers. Lower costs came in the expense of relatively inexperienced and incompetent legal service provided. Equal access to justice is said to be one of the most fundamental cornerstones of a civilized society. Indeed, back in 1919, American lawyer Reginald Herbert Smith warned that, quote, "without equal access to the law, the system not only robs the poor of their only protection, but it places in the hands of their oppressors the most powerful and ruthless weapons ever created." The right of access to justice is a right that safeguards other rights, and ensuring equality of access to is fundamental to the system of the rule of law in Hong Kong. The government of Hong Kong has long upheld the value of access to justice. Article 35 of the Basic Law reflects its importance as one of the fundamental rights for citizens in Hong Kong. Indeed, with the support of legal aid since the late 1960s and with the implementation of various other schemes such as the duty lawyer scheme and the free legal advice scheme, the right to access to justice has been protected since the late 1970s. Indeed, the legal aid policy objective is to, quote, to ensure that no one with reasonable grounds for pursuing or defending a legal action is denied access to justice because of a lack of means. As a matter of fact, Mr. President, individuals face issues on a daily life basis that could potentially benefit from timely and quality legal assistance. For example, losing employment due to discrimination against disability or race, breach of contract and sales and purchase agreements are some typical examples. Early legal advice not only can play a crucial role to help prevent the escalation of legal problems, but also potentially reduce the subsequent costs in other social economic policy areas, in welfare, healthcare, and housing, for example. Yet, in addition to a legal system that is too costly for the community to access, inadequate early legal advice and assistance is also one of the major problems faced by the general public in Hong Kong. Barrister and human rights consultant So Chum described the phenomenon essentially as a Rolls-Royce version of the law. Quote, according to the 2008 DOJ study, number one, 79% of household and 65% of SME respondents consider most people did not know what to do when faced with a legal problem. Number two, while as a profession, Hong Kong's barristers, out of which 52%, and solicitors, 37% of which, have provided pro bono services, by comparison to counterparts in England and Wales and Australia, they are reported to do less. End of quote. A report conducted by the Global Network for Public Interest Law identifies shortcomings of the duty lawyer scheme. This includes the scheme being reactive, where a solicitor or barrister is assigned to only one hearing and there's no follow-through between court appearances. Inadequate legal advice and consultation before representation is occasionally with only 15 minutes available before a court hearing on the day of the plea for duty lawyers to meet with a client. A defendant can expect to be represented by a different duty lawyer at each interim hearing, and only a handful of public interest lawyers are available in Hong Kong. The difficulty to approach pro bono lawyers with the right expertise on short notice. What's more, the free legal advice scheme is one-off legal advice section with no follow-up. Even in the rare cases where there's follow-up, the time lag and the fact that a client has to speak to a new lawyer each time after the first appearance will no doubt affect the quality of the legal assistance provided under the free legal advice scheme. This essentially amounts to a barrier to access to justice, especially if the client is vulnerable. More often, only a short period of time is available between lawyer and client, and with no follow-up. The section might be wasted if the advice is not properly explained, which the client will likely not act accordingly. Besides, although the free legal advice scheme is free of charge, free legal advice will be refused if the issue presented involves complicated legal issues requiring detailed studying of documents. There's indeed a significant gap in provision of free and early legal services in Hong Kong. Limited assistance is available for an individual to obtain early legal advice. The current waiting time can be up to 8 weeks for a free legal advice scheme where an individual is only entitled to a 30-minute interview. Quoting from Bentham, delay not only tended to reduce, if not altogether eliminate, the practical value of a judgment, but it also did reduce the likelihood that the judge would reach the right decision. Delay could lead to destruction of evidence and the fading of memories. Unnecessary delay could cause justice to be delivered too late to benefit the claimants. Subsequently, the effect of a delayed judgment may render effective execution or enforcement impossible. Mr. President, in comparison, legal service models in different common law jurisdictions are making every effort focusing on early legal assistance and continuity in legal service. Take Australia, for example. A large network of Australian government-funded community legal centres, together with unique models of community legal services, are being offered in each state and territory. In Singapore, the Law Society of Singapore study on the provision of legal assistance in 2006 made two recommendations for the provision of pro bono assistance. Number one, an aspirational 25 hours of pro bono assistance per lawyer per year. Number two, setting up a pro bono service office to look for new programs and to provide criminal legal aid services. The Law Society Pro Bono Service Limited of Singapore work in collaboration with NGOs because they recognize the fact that NGOs are often better equipped to understand the needs of the community. In the United Kingdom, LawWorks as a charitable organization operates to enable access to justice to individuals who are in need of legal services but without means to pay for a lawyer, especially in assistance for small not-for-profit organizations in supporting their service continuation and expansion. Their service often involves 30 to 45 minutes of initial legal advice and the identification of the client's options and next steps, with the possibility of providing further assistance like writing a letter or filing out forms. And what about Hong Kong, Mr. President? Well, we are now still debating whether we should further increase the fees for lawyers. In fact, the Hong Kong government should be aware of the need for early legal assistance and advice. There have been proposals by various consultation bodies or even legislators over the past 30 years for measures that could potentially address the issues. In 1986, the Working Party on Legal Aid examined the option of using the Green Form scheme in England and Wales. The scheme would enable an individual with limited means to consult a solicitor for 2 hours to get initial general advice about their legal situation and the options available and or to write letters. In 1993, the same Working Party received no response after recommending the legal profession to allow qualified lawyers to work for voluntary agencies and to provide free legal advisory services on a full-time basis. And in 2002 came the proposal from Margaret Ng and Audrey Yu, both former legislator and Civic Party legislators, in order to meet the need for proper, timely, free and affordable legal advice. They recommended a community legal service center. It was suggested a border network of NGOs would be able to refer clients to this proposed community legal service center, operate interview centers or walk-in specialist clinics, and co-organize outreach programs for legal education and training with duty law scheme. This was, however, Mr. President, not adopted. Coming to the end, Mr. President, the saying justice delayed is justice denied seems to offer a perfect illustration of the problem of inadequate legal advice and assistance to citizens of Hong Kong. An essential aspect of the rule of law is that citizens should be able to vindicate their rights and to have their claims determined by independent judges in accordance with the law. If justice is delayed excessively, not only will the ability of litigants to use the legal system efficiently be impaired, but also a denial of justice altogether in extreme cases. Ensuring the legal system delivers timely justice for all calls upon the government of Hong Kong to fulfill its constitutional duty of resolving disputes in accordance with the law. The fees for duty law service should be increased accordingly without hesitation. Individual access to justice should be further protected and guaranteed without delay. Mr. President, knowing that the Secretary is also present today, I also wish to make a very clear and sincere message to the Secretary that there are plenty of people in Hong Kong who might have some income, some amount in their bank account, but they simply cannot afford a lawyer. Lawyers are way too expensive in Hong Kong, and we should really reconsider and have an adequate review of the system as a whole. This bill, of course, we will have full support, but on the other hand, I wish the Secretary would understand that this is simply the first step of a long, long way of reform and also access to justice. Mr. President, I rest my case.
Mr. Dennis Kwok. Thank you, Mr. President. Members talked about some hierarching principles on rule of law and legal aid, and I do not wish to repeat what they said. I'm sure everyone understands the importance of legal aid, and it goes without saying that Hong Kong's legal aid system is already one of the best in the world. However, we must make distinguishment between civil legal aid and criminal legal aid. Civil legal aid has been outstanding, and in recent years, the government expanded or introduced more resources on civil legal aid, and different cases have been included. So the situation with civil legal aid is satisfactory, but for criminal legal aid, much is still lacking. Compared with civil legal aid, criminal legal aid is often more significant. Criminal legal aid has to do with the freedom of an individual, and being prosecuted by the government has great bearing on an individual's life. So for the public, criminal legal aid is even more important. However, over the years, the legal sector saw that the resources given to criminal legal aid is far inadequate. A few years ago, when we looked at the litigation, there was a sharp rise in litigation fees because for counsel and solicitors, the fixed legal aid fees for criminal cases were extremely low. A lot of people from the legal sector told me that they were unable to take up those cases even if they wanted to, because they might lose money. If you are to visit a prisoner for instructions, solicitors can only ask for reimbursement from the court if they are accompanying counsel, but if they go alone, they won't be reimbursed. So this is just bizarre. And we have been hoping for improvements, and indeed there have been improvements. But these situations still persist. When solicitors and if solicitors and counsel take part in legal aid cases, they might lose money. And some solicitors might have enough work already, but some counsel and solicitors would be deterred by the low legal aid fees for criminal cases. But that said, some people would continue to take up legal aid cases because the legal sector believes that this is meaningful to our society. However, for criminal legal aid, the fees are only raised every 2 years upon a review, and this time the rise is only 4%. So if the base figures or baseline is so low, when you look at the resolution and the relevant fees, when you look at the per hour rates, there is a huge gap with the private practice. If criminal legal aid is so important, why are so few resources invested compared with civil legal aid? As I said, criminal legal aid might be even more important to the public. And is the scope of criminal legal aid enough? If you are arrested by the police, can I enjoy legal advice by a criminal legal aid? Sometimes the police would say you are free to call your lawyer, but for someone who has no money or with no experience in dealing with such incidents, or if they do not know any lawyers at all, how can their rights or legal rights be safeguarded? the police, even if the police says you can call your lawyer, it would mean nothing. Very often when evidence is taken, no legal advice is given. For counsel and solicitors involving in criminal cases like myself and Young, the taking of evidence is very important, and that is sometimes the key to winning and losing a case. So it would depend on what you say during the evidence taking, whether you say anything wrong or whether you enjoy legal advice. This is significant. So on criminal legal aid, we have been asking for an expansion to police stations or arrests made by, or for persons arrested by law enforcement officers. They can call duty lawyers immediately for legal aid or legal consultation. That way, we can have a complete criminal legal aid system. During the umbrella movement, there were mass arrests. A lot of people were arrested. So a lot of lawyers from the legal sector voluntarily went on call around the clock 7 days a week. So whenever a protester or student is arrested, they would visit the detention places or police stations immediately to provide free legal services for these protesters. A lot of those protesters were students who had no money for lawyers. So if the students said something wrong inadvertently during the evidence taking and they were recorded, they would become part of the evidence, which would have a bearing on their lives or future. So the current scope of criminal legal aid is not enough. I hope the government would review this immediately. In terms of duty lawyer service, it has not been reviewed for more than 10 years. And if you have been following discussions at the AJLS panel of LegCo, as vice chairman, a lot of members are interested in reviews of the duty lawyer service. And again, DLS can be extended to police stations, and the current resources given are far inadequate in supporting the lawyers or the amount of money required. And the AJLSP will keep tabs on DLS as well. So hopefully the Secretary can also address this. We need to talk about the importance of criminal legal aid and DLS, because some people ask whether there's any overlap between DLS and criminal legal aid. In fact, there is some overlap, but if we provide proper criminal legal aid, if we expand its scope, we might not need DLS at all. The purpose of DLS is to cover for deficiencies of criminal legal aid. If we review both systems together, we can focus our resources on a comprehensive legal aid system, which would take care of all the needs of criminal cases. This is something the government should review. In the policy address, we saw that the legal aid department will be transferred to the ambit of the Chief Secretary, and this has been a suggestion raised years ago, and the legal sector supports this transfer. We are happy to see that this would be implemented within the year, and the LAD would be transferred to the ambit of the Chief Secretary. This shows the government's commitment on legal aid and more resources would hopefully be allocated on legal aid. So apart from reviewing the legal aid fees, I hope the Chief Secretary would also review the entire legal aid system, including civil legal aid. We have been talking about expanding its scope for years. And we should also enhance the LAD's services. The LAD examines criminal and civil legal aid applications.
同埋公務員呢，都係非常之專業、非常之謹慎咁樣去行使佢哋嘅公職，亦都係咧每一單案件我所知道嘅都係非常之專業、獨立咁樣去處理每一個申請，按呢個法援條例同埋有關法律咧係去批出呢個法援嘅。咁所以其實喺呢一個議事廳或者出邊，成日都會有啲人去批評法援。
That's why in this council, in this chamber, people always complain that the legal aid department is granting too many applications. It leads to abuse of legal aid, but it's really unfair to the legal aid department. As I said, for every colleague in the legal aid department, everyone is most professional in granting legal aid. So don't maliciously criticize the lawyers and civil servants in the legal aid department who are performing their duties properly. Now, if you accuse them of casually granting legal aid and allow people to abuse it, that means you don't know the system. And you don't understand also the basis for granting legal aid. For criminal cases with legal aid, if you look at numbers, there's a high figure of success rate of defending oneself. Without legal aid in criminal cases, and you can see people don't have a chance to defend themselves. So, therefore, from figures you can see legal aid in criminal and civil cases have helped those involved to be given justice in court. So we must not underestimate the independence and neutrality of the legal aid department. Finally, I have to explain why legal aid is so important. My other colleagues have spoke on the principles, but legal aid, I must point out, is important for the effective operation of the courts. Now, when a person is a defendant in a criminal case or he is one of the parties to a civil case, when he is not represented, then the court will have an onerous load. A judge conducted an objective study. He said, in a case, one party is not represented, then the court would have to spend 30% more time on the case than on other cases. So there is a backlog of cases in court, and there's a long listing time in court. Why? Because for many cases, unfortunately, one or even both parties to a civil case are not represented. So this severely impacts on the effectiveness of the judicial system as well as its sustainability. We could enhance the quality of legal aid in criminal cases so more lawyers are prepared to take up such cases. It will help the operation of the judicial system, and it benefits the rule of law in Hong Kong. So we hope the Bureau would not just review biannually and then increase the fees. That's not enough. I hope the Bureau will have a comprehensive approach in conducting a review to cover all aspects. This will help the development of the legal system. At the end, more will be able to benefit. Thank you. Mr. Kenneth Leung.
On the legal aid in criminal cases,
Amendment Rules, 2017. Indeed, I must declare my interest first, Mr. President. I am a practicing solicitor of the High Court, although I don't have much chance of doing criminal cases, as I myself is a practicing tax lawyer. And in fact, I think in this chamber, rarely do we have a chance to have a very in-depth debate of our legal aid system, in particular, criminal legal aid. As my honourable friend Dennis Kwok has pointed out, legal aid in criminal cases is really important in the administering of our rules of law, because a person's, individuals, accused fate and destiny could possibly be jeopardized if he or she doesn't have legal aid or a capable lawyer to defend his case. In fact, the right to a fair criminal trial has been described as the birthright of every citizen, and it has also been said to be axiomatic that a person charged with having committed a criminal offense should receive a fair trial, and that if he or she cannot be tried fairly for that offense, he or she should not be tried for it at all. Now, in fact, for a fair criminal trial to take place, not just should we have an independent, impartial court, access to justice is very important. Now, under the present legal aid system administered by the Home Affairs Department, there are 3 completely different types of legal aid schemes. Now, of course, in 2015/16, the fee for the criminal legal aid has been increased, reflecting the rise in the legal fee, which has not been taken into account for many years. However, for the past 20-odd years, the government had been neglecting the demand for the rise or increase in the fees payable to the duty lawyers, which is a completely different legal aid scheme. Now, let me tell you how the legal market works, my Honourable President. In fact, if you can look at what the small firms, the medium-sized firms and the cities firms, and the barristers are charging these days, it is not difficult for us to see that the amount attributable or allocated to criminal legal aid or the duty lawyer scheme are mediocre. It is insufficient. For a newly qualified lawyer in a very small firm, the average charter rate would be ranging from $2,000 to $3,000. The top partners in the city firm is about $12,000. A barrister or senior barrister would be charging up to $15,000, and it is very common. And it is not uncommon that a senior counsel could command a fee of about $20,000 an hour. All I'm talking about is the hourly rate. Now, in terms of the 2 different legal aid schemes, the first legal aid scheme concerning about legal aid will pay for the fees for district court, the court of first instance, the Court of Appeal, the Court of Final Appeal, and also committal proceedings in magistrates. Now, whereas the duty lawyer scheme, this is what the rule is talking about, is a scheme jointly set up by the Law Society and the Bar Association. It's a kind of joint venture NGO. Now, it is meant to help those victims in the magistrate court level. Now, however, when I look at how this rate adjustment mechanism works, I'm very puzzled, because the rate here has been linked to a basket of consumer price index, category C. Now, although I'm quite aware, Mr. President, that this kind of mechanism has been used, the category C consumer price index, which is a basket of commodities and goods, excluding rent, as far as I can remember, is a kind of general inflation index. However, Mr. President, the charter rate or how the salary level of lawyers
because I'm in the solicitor profession, I can talk about lawyers. Their charter rate and the salary trend are not really linked to the consumer price index. There is no linkage, direct or indirect, of the fees to the consumer price index. In fact, there are three factors which will affect the charter rate chargeable by solicitors. And although I think in the present circumstances and pragmatically, it would be quite difficult for our adjustments to be linked to the charter rate of solicitors working in this city. But however, I would just have to share this with you. There are three main factors. One is the overhead cost of the firm, which is basically, I think, the main cost of a firm will be the rental. And secondly, is a salary trend of solicitors. And is inextricably driven by external economic factor, including the numbers of transactions and the number of deals taking place in this jurisdiction and in the neighboring jurisdictions. And thirdly, it is the complexity of the transaction or the advice concerned. Now, honestly, I cannot see how the legal aid department or our legislature here could try to link up the adjustment level with all these pay levels or the overhead level of legal practitioners. However, there are other reference points which I think you should take into account. For example, there is the annual pay trend conducted by major consultancy firms, headhunters, firms like PA consultants do have the legal market survey, and it does give you a very clear picture of what each categories of lawyers are charging. And in fact, if you want to improve the quality of the duty lawyers, Mr. President, you should really consider trying to link up the biannual revision of the level of the duty lawyer fees with the trend of the criminal lawyers or the criminal barristers. And it is not difficult to get to these two types of information. And I think the legal aid department should think hard whether the linkage to the category C consumer price index should still continue. Although, as I have said, you may want to do it as a starting point, but it is unsatisfactory. In fact, when I talk to departments like the water supplies department, they are reviewing the water supply from Donggang. They're just making reference to the consumer price index basket as well. So it is quite ridiculous because every department seems to be, using this basket of consumer price index to be a reference point. Well, but indeed, you can do that, but I think the trend of the charge of the lawyers should be looked at. Now, if we look at the general criminal legal aid system, apart from looking at the level of fees, the access to justice is a very important component of our rule of law. Apart from having an impartial, independent, transparent court system and impartial, independent judiciary, the access to legal service is the key to preserve the rule of law in this city. Now, if we look at the criminal legal aid system critically, it is quite easy to identify a few gaps, which I think the Home Affairs Department should be paying much more attention to address these gaps. First of all, the government legal aid funding merely focuses on representation, and there is a limited assistance for individuals to obtain early legal advice. What does that mean? When a person is being apprehended by a police officer and he is being detained in a police station, he or she would need legal advice at that stage. And merely, like what Mr. Dennis Kwok has just said, the police officer would just ask you, if you have a lawyer, you can call him. You can call your lawyer. But common grassroots people, common citizens, would be difficult to get a lawyer offhand, let alone to get a lawyer to deal with the relevant situation at the police station. There's nothing at all which the present legal aid system could assist any person who has been detained in the police station or other law enforcement agencies. Second, legal aid only concerns or covers the proceeding stage, and the application for legal aid itself is a process that requires legal analysis, but currently is not covered by legal aid. Mr. President, I'm talking about the application procedure for legal aid, which is also important because one has to decide whether to proceed, or in criminal case, of course, there is not much of a choice. If you are being charged by the government, the Director of Public Prosecution is laying a charge on you, there is perhaps very limited choice in, putting up defense. In 90% of the cases, I believe, you have no choice, but you do have to put up your defense. Either you do your defense by yourself, or if you have enough financial resources, you get a very reputable criminal lawyer, or the legal aid. So, doing this analysis at this preliminary stage, whether or not you should get a legal aid, or whether you are qualified for legal aid, is important. Thirdly, in criminal cases, most defendants only get access to a lawyer, which means here, this is what the rules talk about, duty lawyers in the magistrate court, before the first hearing, Mr. President, and not during the police interview process when the statement of the defendant is being taken by the police. Often the client will only have about 15 minutes to discuss the cases with the lawyer in the police station, and this is quite insufficient. And in a situation where one is detained by a police officer in a police station, a mere 15-20 minutes interview by a lawyer is not adequate. And the duty lawyer will have no use at all during this interview process, unless, of course, the defendant has his own lawyer attending the police station for him. So I would like to urge that the Home Affairs Bureau should look into whether the duty lawyer service should, as a pilot scheme, extend to people who has been detained in the police station and charges are being laid on them. And then an ancillary scheme called the Free Legal Advice Scheme, which is in additional to the legal aid system and also the duty lawyer system, is a one-off 30-minute advice section with average 8-week waiting time, and this is highly unsatisfactory. Mr. President, if we want to overhaul and review the legal aid system, I think it is better to review these three schemes together and not just making piecemeal adjustments every year or every 2 years. Now, of course, I'm talking about the criminal legal aid system here, and I don't want to digress into the civil area because, as you all know, if a charge is being laid on a citizen by a government, the consequence can be dire and serious. And Hong Kong always have a very high rating in terms of our rule of law in this city. And in fact, in the most recent survey, we come up as amongst the top 20 jurisdictions in the world, and we are leading other Asian jurisdictions in terms of the rule of law. And I think in our Chief Executive's policy speech, she has stressed that one of the core values of this city is our rule of law and the judicial independence. These are the twin pillars to guarantee that an innocent person should remain innocent, and he or she will get the best legal advice, the best type of legal representation. But without legal aid, we cannot avail this assistance to these people. Thank you, Mr. President.
許智峰議員。
多謝梁議員，要求點算法定人。
Thank you, President. Call for quorum.
許智峯議員。
多謝梁議員。
Thank you, Mr. Leung. I speak in support to this resolution on the legal aid ordinance, and I hope that this resolution can be passed and an enactment date would be established as soon as possible to specify the enactment date of the new fees. And this increase in legal aid fees stems from the biannual review of the fees of duty service lawyers and criminal legal aid fees. The conclusion was that criminal legal aid fees would be adjusted upwards by 4%. And the review reflected changes in the Consumer Price Index C from July 2014 to July 2016. Some members discussed whether the upward adjustments should exceed changes in the CPIC. I do not wish to repeat what they said, but these are indeed worth considering for the government. For this biannual review of criminal legal aid fees, they talked about the criteria and factors they considered before making the adjustment. According to the decision of the Finance Committee in 1993, the government would conduct a review every 2 years to take into account inflation or deflation and any difficulty in engaging the services of counsel and solicitors. And I think it's reasonable to consider inflation or deflation. But as to whether there's any difficulty in engaging the services of counsel and solicitors, this would require further examination on what is meant by such difficulty. If someone is willing to provide the services, does it mean that we have no difficulty? This is something the government should think about. Should this be the criterion? Some members compared the differences between civil and criminal legal aid fees. I'm not being repetitive here because this is very important. For civil cases, we are very often dealing with monetary losses, disputes, compensations, or cases not involving personal freedom. But for criminal cases, they are often to do with deprivation of personal freedom. If cases are not dealt with properly, freedom could be jeopardized, and you can destroy a person's life. So this is about a basic human right. Therefore, criminal legal aid deserves more attention and resources. But in reality, there is little focus on criminal legal aid. As other members have suggested, the difference in fees between criminal and civil legal aid is very wide. And there is a big difference in the experience and credentials of the solicitors involved. So in terms of the difficulty mentioned in the biannual review, the reality is that a lot of counsel and solicitors involved in criminal legal aid do not mind taking less. You can say that some lawyers are being professional because they receive very low fees. We are talking about an hourly fee of $1,000 to $2,000 for the legal profession. Such rates are low. So why would the young counsel and solicitors still be willing to help? And that is they want to ensure justice, and this is something meaningful to our society. That's why some lawyers are willing to take such low fees. For people who are being sued, especially those who require legal aid, we are talking about less well-off people. And for the leftists, does it mean they would ask whether the poor people do not deserve help? When they are sued, the society think that they do not deserve good lawyers because these are just poor people? Are they being looked down upon by our society? In recent years, there have been many cases of political prosecutions. In reality, in cases involving protests or political disputes, a lot of people who were prosecuted were not well off, and they found it difficult to put together enough money for their cases. So are we going to see more cases of injustice? Given the political prosecutions in recent years, I think the reality is clear for all to see. So when we have more and more people in this situation, is it still worth helping poor people? I came from a legal background as well. When I was an intern at a law firm, I was asked whether I know how to write the Chinese character fat or legal. So the character contains the element of the Chinese character for water. So that means we need money to pursue justice. And the public still feels that you need money in order to pursue justice. If you ask a member of the public, that is still their impression. On the other hand, some people would say that even with low criminal legal aid fees, some young people are still willing to help. And counsel and solicitors would need to take up cases when they start off. It's not easy to secure clients, so some people would suggest them to take up criminal legal aid in order to accumulate experience and to secure a footing in the sector. So sometimes that might lead the public to feel that criminal legal aid is only a stepping stone for young lawyers. So for people prosecuted in criminal cases, they are real human beings. So should they be used as stepping stones. Of course, not every solicitor or counsel would think in this manner. But if this is a general trend, is this something we want to see in Hong Kong's criminal legal scene? The defendants are being treated as guinea pigs. So when hiring counsel and solicitors, have there been any difficulties? And what I said were exactly the difficulties. Would the government still continue with this thinking? They would continue to have inexperienced lawyers on board. So does it mean that the government has no difficulty in securing lawyers? This is something the government should think about. So in future biennial reviews, apart from inflation, deflation, and CPI-A or CPI-C, apart from considering whether counsel and solicitors can be engaged, could the aspects I mentioned be incorporated? For example, whether the practicing counsel and solicitors in criminal legal aid are all up to standard. Should this be included in the review? And you should look at the gap between civil and criminal legal aid. Should that be included in the review?
Of course, the civil cases are different from criminal cases. There's no way you can give equal fees for both types of case, but perhaps the gap should be narrowed. Well, we pay a fee for a service, for the service rendered by solicitors and barristers in legally aided cases, whether criminal or civil. Very often they are hourly remunerated, and since the criminal legal aid fees are so low, if the case is long or complicated, well, there's a cap to the fees receivable. But if it's not a legally aided case, if it's the market rate, the market fee we're talking about, the lawyer would receive a much higher fee. But in legally aided criminal cases, there's a maximum, there's a cap. So the more complicated and the longer the case is, the less the rate of remuneration. So if it goes beyond a certain limit, the lawyer in that legally aided case is in actual fact working for nothing. So how can we attract more the solicitors and barristers to be to involve in criminal legal aid cases if we do not address this issue? It suggests that we do not value criminal aid and the service rendered by the lawyers. So why do you refuse to even give them a small and meaningful increase? If we want to save money on legal aid, maybe in the future the government would only be happy if the case goes to the one offering the lowest fee, very much like what the UK is doing, and the lawyer asking for the lowest fee would be taken. If we don't want to move down that particular path, and we should of course, we have to approve the 4% increase, but we should do more in the pursuit of justice. Mr. Houghton Chow.
Mr. President, we are talking about the review of a legal aid cost for criminal cases based on the price index today, and I surely support the proposed bill today, but I would also voice out my concern. Over the years, as my colleagues have rightly pointed out, the cost for legal aid lawyer on criminal cases is much lower than the one in civil cases. Having reviewed the cost for instructing solicitors on hourly basis with a 25% increase for hourly fee, which is done around a year ago, I reckon it's still lagging behind the cost for civil cases. In a nutshell, Mr. President, I believe we should carry out a reform on the cost for criminal services in the long run. After all, access to justice is of paramount importance to us, and we must provide adequate incentive for high-caliber lawyers to take part in legally aided criminal cases. And going forward, there would be a lot of things to be done. We can't just simply pass the bill now and call it a day. We can't do that. What we do today marks the beginning of a long journey. 主席，我爭啲忘記咗我要申報。
I forgot to declare my interest as a practicing solicitor.
類嘅物價消費指數咧，去調整刑事案件喺法。
This is about adjusting the criminal legal aid cost in line with inflation. As some of our colleagues have pointed out, legal aid in criminal cases is a system whereby the lawyers will get much less vis-a-vis working in a civil case. Many years ago, the government indicated that therefore the hourly rate for solicitors, it would be adjusted from 800 to 1,000. But according to the Law Society, for a solicitor with 10 years of experience, the hourly rate is actually $4,000. Although there was some adjustment, still lagging behind the Law Society's indicative rate. According to some fellow colleagues, they think that the fees for the criminal legal aid cases are so low that it's not worth the while. This is not a healthy phenomena. I hope that after adjusting this in line with CPI's there will be a more thorough review later, particularly in respect of fees for the criminal legal aid cases. I've heard from other members that in the future the fees for lawyers in acting in criminal legal aid cases should be pegged to the market rate. Some time ago, the Chief Justice appointed a working group to look into this issue. I understand that the first phase of the work has been completed and the second phase is about to start. And they will be looking into whether there's a need, a more substantial adjustment to the hourly rate received by solicitors in such cases. The last time the hourly rate was reviewed was in 1997. This was about 20 years ago. I expect the working group would make a full announcement on the findings of their study and on the fees payable to solicitors and whether the rate, which has not changed for years, for more than 10 years should be adjusted substantially upwards. I expect there will be such an announcement from the working group. Back to the subject of legal aid in criminal cases and the fees payable. If the fees are not attractive for a prolonged period, it would be difficult to attract experienced solicitors to take part in such legally aided criminal cases. So there's a need for a long-term, for review in the longer term. Some members today point out that fees for solicitors in the future should be somewhat linked to the rankings of solicitors, or the experience of solicitors. If you want to rank the solicitors in certain way among practicing lawyers, well, lawyers know that different lawyers have different areas of specialty. Some lawyers would be focusing more on litigations, and there are also subcategories such as divorce, commercial disputes, or personal injury cases. So things can be very complicated if these factors are taken into account. If we want to rank the different solicitors in order to decide the fees payable, I think in actual terms it's going to be difficult. So maybe I have to say that this may not be feasible. And again, for fees are payable to lawyers in criminally legally aided cases, they should be adjusted substantially. At least it should be more or less like the fees payable for civil cases, so that more experienced lawyers are willing to take on these cases. So I submit. Mr. Wu Chi-wai. Thank you, President. This resolution is on the legal aid in criminal cases rules. And this is just about raising the fees for the criminal legal aid cases. But if we just talk about the adjustment, either upwards or downwards of the fees, we are not touching the core of the issues. Because Article 25 of the Basic Law talk about equality before the law for all Hong Kong residents, and Article 26, everyone shall have a right to. Article 35 talk about access to the advice of lawyers, of their lawful rights, and for representation. 38 talk about Hong Kong residents shall enjoy the other rights and freedoms safeguarded by the laws of the Hong Kong SAR, and the government should ensure that we have an open and just system for the administration of justice, and the legal aid is there to make up the shortfall, and that is for those who do not have the necessary means, they will still have the access to lawyer service to safeguard their rights. In July, when the Secretary moved this resolution, he said that the purpose of legal aid is to ensure that all those who have who comply with the regulations of the legal aid ordinance have a reasonable grounds pursuing a legal action will not be denied access to justice due to a lack of means. So the financial means is an important consideration. More importantly, through this process, we ensure that justice is not just done, but also seen to be done. In other words, increasing the fees under the legal aid system is not the totality of ensuring justice that to be done. The Democratic Party has always been asking for the independence of the legal aid department, but this is not covered by the current resolution. For justice to be done, and also for justice to be seen to be done, we have to have both. We cannot just do something superficial. There are many more and more criminal cases requiring legal aid, and there are political prosecutions of late. Therefore, it's more important that we should make the legal aid department independent, so that the government would not have doubts about the credibility and accountability of the legal aid department, solely because it is a government department. And this is important for the principle of Hong Kong SAR enjoying high degree of autonomy and Hong Kong people administering Hong Kong. And there have been studies. In 2012, 2013, there was a published report called Consultancy Study on the Feasibility of Desirability of Establishing an Independent Legal Aid Authority. And in that report, it stated that the government has no financial budget for legal aid, for the purpose of legal aid, and therefore there is no need to set up an independent authority on legal aid.
But I'd like to point out that if you look at another set of figures, you will see another phenomenon. In the last 10 years, the legal aid department has an annual budget of $1.7 billion, but that for LAD was just $400 to $500 million per year. What does that mean? That means that 10 years ago, the DOJ and LAD had more or less the same annual budget, but 10 years down the road, the difference between the two is quite obvious. There is another point. Under Head 208 for LAD, the approved estimate is about $500 million, but the actual expenditure is just over $400 million. This phenomenon shows that when the administration sets its estimates, there is actually an invisible cap. As many members were saying, the adjustment for legal aid in criminal cases biannually, according to CPIC, is never going to catch up with the increase in legal costs in the market. And you can see that, in fact, the LAD estimate is always kept at $400 to $500 million annually. I'd like to point out that, given such a background, when the administration sets an estimate for Head 208, it says it would look at the expenditure of legal aid, changes in legal costs, and also the change in scope for the general scheme. In February 2016, a document was submitted to LegCo by the administration, increasing barristers' fees for legal aid in criminal cases. In that proposal, a barrister with 10 years of experience would receive originally $1,500. But in the same court, if it is a civil case, the fee would be $4,000, and that is why there has to be an increase for criminal cases. I'd like to cite another piece of information. For a very long period now, most legal aid lawyers only have 1 to 4 years of experience. I can see this set of figures. Generally, those with 3 to 5 years of experience. Let me see, sorry. We can see that for lawyers taking over criminal cases using legal aid, now because of the improved scale of fees, you can see that relatively more experienced lawyers are willing to take these cases. So I like to say that apart from adjustments according to CPIC for legal aid in criminal cases, you should also solemnly consider whether the legal costs we are paying can really take care of the normal legal costs in the market. In July this year, there is a document from the administration mentioning a concept where legal aid should be extended to people detained in police stations to provide legal advice. I think that is a very important concept. In fact, the first hurdle for any criminal case is people who are in police detention, and when they give the first statement, they should be given legal aid. If this can be extended to this first step, then people who are detained in the police station and are asked for a statement will be assisted. We understand that when police take a statement, they will state quite clearly that you have the right to silence, but whatever you say will be part of your evidence. But actually, many people don't really understand what this statement means. And during the process of giving a statement, they may not know the legal rights, and therefore they may say something that might impair the exemplification of justice. This is not included in the present resolution, but it should be put to LegCo as soon as possible, so this can be put into practice. So people's legal rights will be protected not just during trial, but also from the first step of statement giving in the police station. Because this is going to have an important bearing on future trials, if any. In this resolution, a lot of legal aid fees will be increased according to inflation. We welcome that. But you are not responding to the policy objectives and philosophy of legal aid, which is that anybody who needs it should be protected by legal aid so people can see justice done. From a legal reform point of view, the resolution can only take care of part of the entire issue of the law giving justice to the people. And as I was saying, whether the Legal Aid Council should be made totally independent and whether legal aid should be extended to detained persons, all that should be explored into. And in fact, these have been discussed for many years. Yet, we don't see any resolve on the part of the administration to ensure that the rights of Hong Kong people under Articles 25, 35, and 38 of the Basic Law are protected. The people in Hong Kong also rely on the duty lawyer scheme to have the legal rights protected. This may be a little digression, but allow me to point out that this is also how we protect people's rights. There are now 1,200 barristers and solicitors taking part in the scheme. But you have to go to the court at 9 a.m. in order to look for a duty lawyer. so that within a very short while they have to come to grips with the case and then to help you defend or mitigate. A citizen will pay a few $100s for a duty lawyer to mitigate for him in the court, and the lawyer will be able to advise him the consequences of the case, and then the citizen will have to decide whether to plead guilty or not guilty. All this has to be done within a very short while. And we are worried, and we also question whether people's legal rights are fully protected because of the rush. If you ask duty lawyers to give the best advice in a very limited period of time, it will prove to be very difficult for them. I think we should reform the scheme. Instead of contacting the duty lawyer only in the morning the trial takes place, can we have access to duty lawyers earlier so that people's legal rights are fully protected? Mr. President, I'm coming to the end of my speech, and I'd like to say that the DP will support the resolution, and I hope that you have seen our concern about how the entire legal aid system can give play to justice, justice which is not just written in black and white but is shown to the entire public, especially whether there is this glass ceiling or invisible cap for legal aid. Even if there isn't, there's still a problem. And lastly, in the past, the legal aid department was within the jurisdiction of you, Mr. SHA, but later on it will be transferred to the CS4A. Now, does that mean it gives it more independence? Now, if that is your policy objective, I don't think this will be achieved just by transferring it to the CS4A. A more effective way to do it is, as I said, there should be a totally independent Legal Aid Services Council. If the CS4A will have innovative ideas, we will welcome those, but we will have to make that judgment when we hear exact proposals. But now we have old wine in a new bottle, and I don't think we are going to achieve the policy objectives of transparency and independence. Thank you, Mr. Cheng Chong Tai. Ms. Tanya Chan, may I ask for a quorum call, please?
鄭松泰議員。
Dr. Cheng Chong-tai. I believe that most members agree with the rate of increase of the fees, but I do think that we need to focus on one matter, that is, the increase of criminal legal aid fees. Will it improve quality of the legal aid department? Will it be able to resolve questions, problems we face? Say, for example, whether there will be political censorship when it comes to those who are politically persecuted. If we can pay to buy the neutrality of a government department, of course, it's well worth it. But the fact is, from a lot of authority or cases, we see, well, it's not the case of abuse, arbitral approval of legal aid, but it's political censorship. Say, for example, the second day of New Year riot offenses, there are about a dozen protesters. Their application for legal aid have all been turned down. They say on merit. And in other words, it doesn't involve huge public interest. That's why their applications were turned down. However, when it comes to means test or merit test, how do we follow up if we are unhappy with the result? I do believe that there are some people in the legal aid department that are neutral and professional, as Mr. Dennis Kwok said. But the situation is worrying. Is it because of individual cases or political background that the LAD conducts political censorship? If one has passed the means test, then how come all protesters of the New Year riot application are turned down? Well, there is an appeal mechanism, but that is completely different from a civil legal aid appeal mechanism. Well, if those appeal cases are handled by the same group of people, then 90% of the times these appeals will be quashed. If you are to lodge an appeal yourself, that means they are protesters that are already in prison. They have to engage lawyers themselves. Then you need to ask one question. They are already in prison, so they have limited access to information. They don't know how to make an application. And they are in prison. You will have to wait for an application from the welfare officer or to wait for words to be passed to you. That itself is a mental torture. There is no way for these people to exercise their rights as a citizen in Hong Kong. That is, everyone is equal before the law. You may say that, well, some lawyers or experts, after considering the facts of the case, decide that there is a very low merit. That may be the case, but protesters and people who love Hong Kong are very worried. Are there political considerations when vetting applications? I want to say that in recent years, especially in the past few years, perhaps because of political turmoil or political controversies, law enforcement agencies, in particular the police and the legal aid department, well, the police are too heavy-handed when it comes to dealing with protests and marches. They will just arrest you before they ask any questions. It's not even as serious as the New Year riot. If you're jogging, you may be charged with loitering. So it seems that they would err on being stringent. And these people who are arrested, they don't have the means to voice their dissatisfaction. A lot of people, as a result of these protests, they may just be passing Mongkok. They are arrested and prosecuted. Will they be afforded legal protection through the legal aid system to ensure that they are represented? Of course, some people from the loyalist camp may not agree. They would say that, well, knowing full well that there is danger, you should be hiding somewhere else. Well, but there is the approaching legislation for national anthem. Protesters, if they are prosecuted, Dr. Chang, I think you might have gone to the wrong place, engaging in the wrong debate. Because this resolution, well, if I am in the wrong place, then you should have stopped all other legislators. I don't have to use all my 15 minutes. I think you're digressing, Dr. Chang. Please come back to the topic. I won't use all of my 15 minutes, don't worry. I want to say that given this political atmosphere, the Legal Aid Department, being a supposedly neutral organization, when they vet applications, do they engage in political consideration? If we can pay to buy the neutrality, I do believe the Hong Kong people are more than willing to pay. But given the current political landscape, if you say that, well, these people appear in a protest, so they deserve a prosecution. But the spirit of legal aid is that regardless of your political affiliation, background, race, stance, you have the same rights. Secondly, I want to say that when there is legislation for national anthem, it's not just about protesters. It may be just a housewife in a restaurant. Perhaps the housewife giggled when the national anthem was played and she is prosecuted. Someone said in their seat that I'm nuts. I'm just trying to say that this is not just a problem of being a protester.
Should the Legal Aid Department be an independent? You have to look at all the rejected cases. The LAD says you don't stand a chance, so you have to go to the High Court to lodge an appeal against the refusal to grant legal aid. Where do you have to get the money? Well, I'm saying that if we can spend money and buy political neutrality of the department, I believe most Hong Kong people will be more than willing to do it. Mr. Yip Kun Yin.